My approach to lawsuits reflects the advantages I have from my unique background, and as a result, my complete mastery of the subject matter, as well as my writing ability and ability to improvise. In fact, I spent the early part of my adult life as a jazz musician. And as a former English major, I've written close to 200 articles or documents in my field, including several full-length documents published by the U.S. Department of Transportation. Also, interesting is the fact that the majority of accident victims are elderly, disabled, or children. Three audiences that I have been deeply involved with in the 2 decades I spent consulting: operating a 70-vehicle transportation system for physically and developmentally disabled adults and infants for a decade, and coordinating the design and marketing efforts of 2 European manufactured buses introduced into the North American market. Thus, my unusual career has allowed me to work on both the operating and the automotive sides of the field, much less in multiple types of services. As a result of this background and my experience directing projects at high levels in virtually every non-rail ground transportation mode, I sometimes take liberties that many attorneys are afraid of their experts taking. For example, I don't answer a question the way opposing counsel wants me to when I recognize that the premise underlying this question is specious. Instead, I correct the premise and then answer the question. Such approaches often produce longer answers than my attorneys may like. Yet I have never once had anything I've said in a deposition read back to me at trial, and I don't ever recall being unable to answer a question, other than some detail of the memory test that many of my deposition and trial testimony turns into when opposing counsel learns I not only know every nook and cranny of the mode of transportation involved and its regulatory structure, but every conceivable nuance of the case. Interestingly, I do not feel that the key to winning a case is necessarily the brilliance of the attorney or the knowledge of the expert. Frankly, I don't even think the key is the facts or the evidence. Instead, I believe the key to winning a case is related mostly to the level of effort one puts into it. Particularly in the initial stages of a case, there are numerous ways to signal to opposing counsel the degree of effort he or she can expect to face. When done in a timely fashion, this signal can be intimidating. I also believe that most cases are won or lost mostly at the analytical stage, not in a deposition or during a trial. Here, the mastery of the subject matter and the ability to examine the facts from multiple perspectives come together, and the genuine reasons for the accident or incident emerge. Interestingly, I typically find scores of errors and omissions in many cases. In some, I have found hundreds, and most of them were material to the case. In truth, this is partly because I can usually tell if a case has merit from the initial, often superficial discussion I have about it with the attorney who contacts me. If the case seems to have literal no merit, I rarely become involved in it. I think my reputation bears this out. I almost never get called for a case by an attorney who will likely lose. And not from false humility, but I attribute much of my success rate largely to this fact. Further, I am neither a parrot nor a shill. I will not take a case simply to spit back what my attorney wants me to. Instead, I work with my attorney as a team, accepting advice and guidance from him or her about the legal issues and constraints, while providing my counsel with the technical perspective within those constraints placed upon their presentation by a given state's rules and litigation environment. I also find it common that many, if not most, attorneys initially do not know what transportation cases are really about. This is because, at least in this field, far more issues lie below the surface than are apparent. For example, the principal cause of more than half of the more than 400 cases I've done has simply been that the vehicle schedule is too tight. And to compensate for it, drivers abandon all type and manner of safety procedures, whether trained properly about them or not. So the genuine causation is not always apparent from the outset, and what appears to be the causes are more often merely symptoms of other problems. For example, the basic causation of most molestation cases, very common in special education and paratransit service, is the failure to monitor effectively, and a principal Achilles heel of public transportation in general. When working on the plaintiff's side of a case, I also am far more intrigued by ways in which to multiply the damage award or magnify the settlement than by simply mastering the meat and potatoes aspects of the case. While it varies by mode, many forms of transportation involve regulations that are more often than not violated. I'm not speaking only of ADA violations, but violations of FERPA in the school bus industry and violations of HIPAA in the non-emergency medical sector. While NHTSA and FMCSA violations also occur, most accidents and incidents are caused by driver errors and omissions, not by vehicle-related problems, although in many cases I found both. Depending on the state and whether the defendant is a public or private entity, these violations also translate into an assessment of punitive damages that often dwarf the direct damages. I also encourage attorneys for whom I work to engage in aggressive tactics, particularly when working on the plaintiff's side of a case. For example, if I find a tight schedule to be the root cause of all the errors and omissions this operating environment led to, I encourage my counsel to file for injunctive relief, requesting that the court order the operating agency to add additional vehicles to its fleet. Where I find wheelchair securement equipment deficient, I encourage the filing of injunction to properly retrofit the vehicles that contain it. And in really ugly cases involving mega or national operating companies, where the exposure of their conduct in court would hurt them commercially with respect to their ability to obtain future contracts, the best strategy is often to literally ignore what reasonable damages might be, but instead to force or encourage the defendant to settle for a huge sum to limit the commercial damage that relinquishing the confidentiality of the settlement would uncomfortably lead to. I've also been involved in a number of catastrophic accident cases where, particularly on the defense side, I've often defended innocent vehicle manufacturers and suppliers with deep pockets pulled into the case when the accident's causation was primarily the fact that the driver simply fell asleep at the wheel. I feel particularly acute at recognizing this root problem, as I'm likely the nation's foremost expert on driver and motorist fatigue. My master's thesis dealt with circadian rhythms. I've conducted a major study for the U.S. Department of Transportation involving motorcoach driver fatigue and hours of service violations, and I've written 10 magazine articles on the subject. These approaches appear to have paid off. I've gone to trial on only about 7% of the more than 400 cases I've been involved in, and was not even deposed in more than 80% of them. Finally, regarding the importance of effort, I maintain a library containing at least the last 10 years of every trade publication in every public transportation mode, and attend several trade shows and conferences every year, and have spoken and made presentations at dozens of them. I also do not discard case materials when the case has been completed, unless I'm ordered to, which is rare. So I have a massive library with all the case materials of more than 400 cases. As a result, I have access to scores, if not hundreds, of training manuals, policy documents, and other materials that document the industry standard for performing and properly executing almost every operating function and procedure, and many policy-making, planning, management, and other directives as well. In summary, a genuine expert is an important prerequisite for winning a lawsuit, as well as winning or avoiding huge damage awards or settling favorably. But frankly, nothing trumps effort. And it is the effort I bring to a case that I feel is the most important element of my participation, and which amplifies my mastery of the case's subject matter and my analytical skills. Particularly those skills I apply to the facts and evidence at my disposal, particularly where the causation lies beneath the surface. Thank you for listening. I hope you agree with my philosophy for succeeding in lawsuits in my field of expertise, or at least I hope you will consider many of these points seriously.